Welcome to the Policy Hour. I think it is today we'll be basically doing a deep dive into the New York City Bias Audit Law. From my understanding, from the Policy Hours, we run it in a monthly basis, and we cover, I guess, very different pieces of legislation. Most of them relate to AI across the globe. And today's edition will be regarding the upcoming New York City Bias Audit legislation, the New York City Local Law 144, with which enforcement may start in April the 15th, affecting many employers and employee agencies running their businesses in New York City. Very briefly about myself, I'm Adriano Koshiyama. I'm the co-founder of Holistic AI. And very briefly about Holistic, we are the all-in-one solution for AI risk, governance, and compliance management. In this space of talent management lifecycle, we work with different companies, ranging from the likes of Unilever and the vendors in the space like UKG, JobVite, Hyatt, and many others. We do a lot of work with government and policy bodies. I'm worth mentioning in this area of human resources, OECD, AMS, and IFO, great partners, and we try to influence work done by companies and organizations in this space. So we're very excited about this area, and one of the main underpinnings behind our company and work was this research paper that we wrote back in 2021, 2020 around algorithm auditing. And as you can imagine, this topic now took the form of bias audits in this space, but actually it's a much bigger play if you would think about it. So highly recommend this paper. We talk about several issues that, even though we constrain ourselves around bias, it's actually the play is much bigger, because one needs to think about transparency, one needs to think about privacy, and many other characteristics around auditing. Before I go to the speakers and introduce them, I just want to mention another piece of research done by the team here. A lot of you might be interested in having a look. It's we wrote this white paper on the regulations of HR tech, some key laws that you may need to know that is coming. Broadly speaking, if you're thinking about the place that's taking place, in the US, it's very state level and city level specific legislations. Today we're talking about New York City, but New Jersey is trying to pass similar legislation, as well as California. So there will be way more legislations coming. And one needs to think about how they're going to handle so many of these new requirements before they adopt new technologies. In the European Union, there's going to be a massive piece of legislation coming in the coming months, I should say. It's called the EU AI Act, big intervention, and will definitely affect how people use solutions ranging from recruitment to workforce management in this block. So do have a look. There's way more than those two plays that is happening across the world. And finally, on the specifics of New York City, we wrote this very interesting paper on the local law 144, where we did a critical analysis of this of the metrics that they're proposing. As you may know, some of you, they start with a set of metrics, and then they changed it to a different formulation. We did a very good critical analysis. For those who are more IO in this call, I think you're going to enjoy this research. Finally, I would like to bring up my guests. Maybe they can show up their faces. Here we go. And I'm very pleased to have both here in today's sessions. So first, ask Erly if she could introduce herself.
Thanks, Adriano. Hi, I'm Ellie. I'm a senior researcher at Holistic AI, and my background is in business psychology. So I focus on the fairness and bias associated with these tools and integrate perspectives from both psychology and machine learning because it's a very interdisciplinary field. And in my role at Holistic AI, I focus on kind of the regulation of these systems and how this feeds into making them safer and fairer.
Nice. I should mention that Ellie will be speaking at SIOP in a month's time, and we will be actually sponsoring the event, so see you there. Jacob?
Hi, thanks so much. My name is Jacob Canner. I'm a lawyer at Kroll & Mooring in our San Francisco office, and my legal practice focuses on technology, privacy and cybersecurity, litigation, and counseling. And this includes working with clients to understand and comply with federal, state, and local privacy and technology laws, such as New York's Local Law 144, which we'll be discussing today. And thanks so much for inviting me.
Yeah, thanks for coming, Jacob. We really appreciate you taking part in this. Okay, I have to run an agenda. There's plenty of questions already. I can see them. And I think to start, let's start with the big picture. Could you, Ellie, before we dive into the specifics of the legislation, could you give us an idea about the scale of automation in HR and talent management and talent acquisition, etc.? Would be great to know some figures and just to demonstrate that this is not a small niche that's happening.
So estimates suggest that around 78% of businesses are either currently using AI in their recruitment practices or they're interested in using it, and around 7% of businesses are actually fully automating their approach. So there is no human involvement. There's kind of automation from the very start, applying to kind of offering the position. This is more common in larger businesses, especially to have it fully automated. It's more useful for roles where they're hiring a large volume of candidates. So for example, in graduate schemes where there's all of these CVs to sift through, all of these applicants. So it just kind of reduces the time to hire, makes things more convenient for both applicants and the hiring managers. But it is becoming more and more common in smaller businesses too. And this technology can be used in multiple ways. So for example, screening resumes, doing psychometric assessments, video interviews. So there are kind of a wide range of applications of these tools, and they are becoming more and more common. It's not just a handful of businesses that are using it now. So that's why it's so important that we are starting to see these regulations around the systems.
Before we go to the specifics, just a follow-up question, Annie, is I guess business uses these techniques for some reason, right? And could you tell us about apart from the compliances, but the benefits that have on using these systems in the first place?
So aside from the time savings to kind of sifting through these large volumes of applicants, it can also make the experience more engaging. So if we've got things like video interviews or game-based assessments, because there's these interactive elements, it can be more engaging for respondents. This can reduce test-taking time. It can also mean that there's less test-taking anxiety. So this can help to actually improve performance. With an algorithm as well, we can potentially mitigate any biases that might be harder with human biases that are kind of harder to mitigate, especially if they're unconscious. So there are benefits on both the applicant side and the employer side.
Yeah, I can imagine the time saving and the experience component. I'm not so old, but I remember doing this pencil and paper tests around psychology, and it was I can imagine how it was difficult for someone to come and do the scoring afterwards of every single person. So, and it was not very engaging, I should say. Now I turn to Jacob, but before I turn to Jacob, I'm going to launch a poll where I'll be asking if our attendees, if you are ready for the local law 144. So I'm launching this poll right now. There are different questions regarding your level of readiness, ranging from I'm compliant to I'm ready, I've commissioned audits, or I'm preparing, I'm out of scope, or I don't know which requirements are. So there's going to be plenty of data for us to explore more, Jacob, after your intervention. Maybe people change their minds after you intervene now, but could you Could you provide to us, Jacob, a little bit of a background and high-level understanding about this legislation?
Definitely, yeah. So the law, as you've said, will go into effect in April 2023, which is 1 month from now. And even there, it's not clear that it will in fact go into effect, because it's a possibility that the city of New York will choose to delay it. Some context on how we reached this point, I think, is useful. So initially, the law was supposed to go into effect on January 1 of this year. But in December 2022, it was announced that the law would be delayed. It appears the reason for the delay was the substantial interest in the law and the substantial volume of comments provided to the city about the law. Now, the law regulates automated employment decision tools. So this is tools or technology that a company uses, as Airly said, to assess either hiring people or promoting them. The law's regulations related to that are, consistent with what you see in other privacy-related laws across the United States, at least. There's a notice requirement, which means that you need to provide notice to the applicant or the person for promotion purposes about the use of the law. And there is an audit requirement, which means that in order to use the tool, you need to complete an assessment of the tool's processes. What is the results of the analysis, and disclose the results of those audits so that the people who are the subjects of the tool can at least understand how the tool operates. As I mentioned, the law is supposed to go into effect, but is not yet, and it might be delayed. We just don't know. There have also been 2 rounds of regulations that have been proposed by New York City's agency enforcing the law, the Department of Consumer and Welfare Protection. And these have been trying to clarify and define more precisely the scope and bounds of what the law covers. Despite this, there's still a lot of questions, and there's a lot of open items for this new law and how it will look.
Yeah, just to share some of the results of the poll, because even though it's still running, just to give you an idea, most of the attendees here are still some are out of scope because they don't have employees or candidates in New York City. I would say 34% apparently, but 24% they are preparing their audits at the moment, or they're gathering data, or they're researching for bias audit providers. And the other 24% are unsure of the requirements. So I'm hoping that for the 24%, we can try to, by the end of this policy hour, we can give them a bit more understanding. But just to get a bit of a scope, just to help them understand, the scope of the legislation applies to candidates or for those applicants seeking jobs who are New York City residents, right, Jacob?
That's correct, Adriano. So it's a New York City law, and so the jurisdiction covers New York City. And there's actually, if you look at the text of the law, there are 2 provisions in particular that define the sort of geographic scope to the city of New York. The first is covered in the provision that describes the notice requirements. So this notice provision states that notice must be provided to, quote, an employee or candidate who resides in the city. Now, I'll note that at the most recent set of, at the hearing on the most recent set of proposed regulations, there was a concern that this resides in the city provision might lead to an unfair disadvantage for people who live in the city. Because does that mean that if you're a candidate who lives outside the city, going for the same position, no notice is required and they might be fast-tracked on the application? We don't know how the city is going to respond to that concern, but that is something that was raised at the most recent hearing. The second provision relates to the definition of an employment tool, and that also clarifies that the law only governs persons who live in the city of New York.
Yeah, that's the provision which is, I think, is one of the most interesting. And I guess a lot of people get confused about this automated employment decision tool, and it's not common that when we do calls with some interested parties, they think that the legislation is about AI for some reason. And I wonder whether you can share, Ellie and Jacob, some light around what does it mean to be using an automated employment decision tool. Maybe I'll start with Ellie first.
So as Jacob mentioned, there was the original law that was passed by New York City Council, and then the Department of Consumer and Worker Protection, or the DCWP, have proposed their own rules. So according to the original legislation, an AEDT, or automated employment decision tool, is defined as a computational process that's derived from machine learning, statistical modeling, data analytics, or artificial intelligence. So I think that's where they're getting kind of this focus on AI, but it does also include just computational processes, statistical modeling. So it isn't just limited to artificial intelligence. And they kind of also specify that the outputs are simplified things like a score, a classification, some sort of recommendation, and it's used to substantially assist or replace discretionary decision making. Then the DCWP kind of proposed some clarifications to this. So they say that an AEDT is a tool that substantially assists or replaces discretionary decision making, and this means to solely rely on a simplified output with no other factors considered, to use a simplified output as one set of criteria, and this is weighted more than any other criteria that's considered, or to use a simplified output to overrule other decisions. So as you mentioned, Adriano, it isn't just focused on artificial intelligence. There are these other systems, and the law has actually quite made it clear it's about how the system is used and kind of the scoring method rather than the artificial technology or artificial intelligence technology.
Jacob, could you expand? But particularly, we get some clients, I would say, or prospective clients or parties interested, confused about the decision word as part of that list. They feel like the algorithm doesn't make a decision whether someone gets employed or not. I make a decision. So can you just qualify that a little bit more?
Yeah, no, it's right, and it can be complicated, and the law, I think one way that we try to describe it to clients is that the law is trying to protect the persons affected by its law. So if it's a privacy law, it's trying to protect the consumers, and in this case, it's a law trying to protect the subjects of employee hiring and promotion decisions. So, you want to look at the text of the regulations in the law itself to understand precisely the scope. But if there's a process where you're making such a decision and you're relying on the tool in some way, you should be triggered. Is this covered by the New York Local Law 144? It's not just about the autonomy that you have versus sort of control of the technology and deciding, but it's more of a flexible approach where the city of New York is trying to protect persons that are being impacted by the use of the tool. It's as we mentioned at the beginning, it can be extremely useful and even necessary to use technology to facilitate these business processes so that it's not too burdensome. And the city has reflected an interest in that through their regulations and the public statements made about the law. But they are equally interested, at least equally interested, in protecting the persons that are subject to it. And that's the balance that you need to think about in terms of complying with the law.
Yeah, that's quite interesting. I want to go to we already on the section 2 around the areas of uncertainty and the scope. Another one that we now less, I would say, but it was part of the debate for a while, which I think also in the New Jersey version they made a small amendment in some ways, is this concept of independence and impartial auditor. And in the rules they have explained it at least they had some criteria around what does it mean to be independent and impartial. Could you expand a little bit more, Jacob, if possible?
Yeah, absolutely. So, and this has been clarified in the regulations as well. At first, it was unclear whether the same company that was completing the hiring decision could also do the audit in-house. The city of New York has stated that that's not the case. The audit needs to be completed by a party that is not related to the company that is making the employment decision. And if you're using a vendor, they cannot have a financial interest in the company that is making the hiring decision. This requires more prep time, I would say. If you're going to be using an AEDT, an automated employment decision tool, you need to make sure that you have identified someone to complete your independent audit. And, it's got to be independent. So you got to find someone new to do that. And that actually, there are a lot of companies out there that'll do that, thankfully. But that takes time to find them and to find them in a way that works, and then to make sure that they have the resources necessary to complete the actual audit. As Adriano and Airly can talk about much more eloquently than me, it's a lot of work to complete the audit. It's complex and you want to do it right. So that's just sort of another area that you need to keep in mind. Moreover, the law requires yearly audits. And so it's not just about doing this once and putting it on the cupboard. It's maintaining the good system. It's maintaining the relationship with the vendor to ensure that you're in compliance with the New York law.
I just want to, there's been plenty of questions, and I'll try to fit their questions also as we go along. I just want to mention very quickly, it's being recorded, the webinar, and will be shared with attendees. So it's not a problem. And the second one, definitely the deck can be made available as well. So we will make sure that all these materials are shared with all of you. One of the elements, and maybe Ellie can jump on this, and there could be a community of IO psychologists in the call as well, business psychologists, is even though the bias audit is much broader than that, but at the core of the bias audit is the adverse impact analysis, which is, you calculate the impact ratios, and there's different metrics and different ways and all the rest of it. But I'll let Ellie, could you highlight, Ellie, more or less, what is the big differences in the whole impact ratio calculations that the law is mandating, as well as the details around which demographics we should look for and the intersectionality among them?
So the law says that the impact ratio should be calculated for, at minimum, sex/gender and race/ethnicity, and it does specify some particular categories that should be kind of investigated within this. If you do have additional data, so if you do have data related to age or disability, for example, you can also audit for bias against these characteristics. But the metrics that were proposed by the DCWP, there are two. There's one for binary systems, and then there's one for regression systems. So these are systems that result in some sort of continuous score. So for example, if we were calculating a personality score, this would be a regression system as opposed to a classification system. So under the uniform guidelines in the US, companies are required to test for adverse impact based on the 4/5 rule, so the hiring rate of one group compared to the hiring rate of the group with the highest rate. The DCWP kind of borrows this metric for continuous systems, the categorization systems, but it doesn't give a threshold that you have to use the 80%. So as long as you kind of use the calculation, there is no threshold for determining bias. This is kind of up to the discretion of the auditor to then make recommendations on whether the data shows evidence of bias or not. But they've also proposed this novel metric for regression systems. So because it's not a classification output, we then have to kind of categorize these scores to then test for adverse impact. So they have what is called a scoring rate. So you calculate this based on the median score and whether people in the group score above this median score or below. So they're kind of categorizing and thresholding based on this median score. And they then use a metric that's similar to the categorization one. So you compare the scoring rate for one group to the scoring rate of the group with the highest score. So they've kind of proposed this novel metric. Previously, they did propose one that was based on the average of the group, compared these, but without binarizing. And it was kind of too novel. There was, and you'll see in our research paper, it doesn't really reflect what's going on. It's not appropriate if there's kind of unexpected distribution. So this new metric they proposed is more useful, but again, it is novel. So they are kind of revising and kind of following industry best practices and any feedback from industry, but they have proposed these metrics, and this will kind of help with the impartiality too. So if auditors have to follow these metrics and they can't kind of choose metrics that might give them more positive or kind of more desirable results. So for example, if under the 4/5 rule, it shows bias, but then under the 2 standard deviations rule or Cohen's D, it doesn't show bias. This could potentially allow employers to kind of twist their results, but having these metrics specified, this means that it kind of increases the impartiality. So everyone has to follow this one metric, and they can't pick and choose the metrics that will show them in a more positive light.
Yeah, it's very interesting, and I think it's for those who are more traditional IOs, the most interesting thing is the idea that you have to do, which some of you may be doing already, but in general, it's not a typical thing. We should do an intersectionality between groups. And we wrote a paper, by the way, I should mention about this. And if you are able to produce your bias mitigation in intersectionality, it cascades up in many metrics. So if you fix bias in some intersectional group, let's say Black women, for example, you are also fixing on gender as well as in race at the same time. It's just incredible how mathematically and these things can cascade up in a very interesting way. Anyway, big topic aside. Question is for our audience, before I go to more questions from the audience, but for Jacob and Ellie. April 15th is approaching. We heard, it's also on the website, that they're still working on the final guidance or something like this. So it feels like even though April 15th is approaching, it feels like that there could be another kicking the ball down the road. It might be that this could be the last time that they actually will do it. Any recommendations or suggestions that you make right now, Jacob and Andy, before we go into the more business imperatives of how should our attendees here today and the ones that will be watching this in the future should approach this problem at the moment? Yeah. Any recommendations and suggestions? That would be great. Jacob, go for it.
Yeah, thanks. So to your point, in a February update, the New York regulatory body said that, and I'm reading what they said, is that they're reviewing, quote, the substantial volume of thoughtful comments that they have received about the rule, and that we plan to finalize our rules and begin enforcement in the coming months. So, I think that it's because they have said that the rule will be in effect on April 15th, and they have not changed that statement. It is still important to treat April 15th as the day that it will go into effect. That being said, in their February update, they did not say April 15th. So it's difficult exactly how to interpret that. But I guess the first thing I would say is, to the extent you're using an AEDT, monitor the City of New York's notices about it, or have someone that you're working with monitor it. So, you asked about things to do to prepare in the next month. If you do think you have an AEDT, but you're not sure, talk to someone. This is the time then you should really be communicating to understand. And if you do have an AEDT and you haven't taken the steps to comply with New York law, this is definitely the time to do it. There is still time to make sure you're in compliance. By April 7th, it's still possible, but it gets more tight, right? So this would be the time to start talking with vendors about completing an audit, or with counsel about confirming whether the law covers your business.
I'd also add to that you can start collecting the data, make sure you've got everything you need. So if you don't personally collect this protected characteristics information, if you partner with someone else who does, you can potentially start to kind of gather it from them. You are also permitted to use synthetic data, so run a test panel, as long as you are explicit that the audit has been conducted on this test data. It's also important to consider the future implications. So I know some of our audience said that the law doesn't apply to them. They don't hire from people within New York City. But by not getting the audit, this means that you limit yourself in the future. So if someone did apply to your company, you would then have to find an alternative. So you might have to manually screen them, or you might have to then procure an audit before you can actually use the tool. So just kind of be aware of any implications of not acting.
Yeah, that's an interesting aspect of the law, right? It's just before you use an ADT, you need to have an audit, which is, it was always like a bit of a chicken and egg problem. And they managed to create a concept of sharing audits in some ways, as a system level audit that it could use data from different companies and putting them together into a single audit. But which, by the way, is one of the questions in the Q&A, Jacob and Ellie. What is if you're a company, if you're like a large enterprise, I don't mention a specific company, but imagine like a large enterprise, you're using different systems from candidate matching to resume parsing and assessments of every single form, etc. And then you're sitting as a lawyer in many ways, Jacob. And would you prefer to conduct your own audits internally, or would you prefer, for example, to maybe use a bias audit provided by a vendor? What's your take? Of course, if it's the first time you're going to use the technology, unfortunately, you're going to have to rely on the vendor for that. But let's say you'll be using already technology for a while. How is that? How that could go?
Right. No, it's a really good question, and these are important questions that can have legal impacts. So sorry to give the legal answer, but it's always important to talk about it with counsel, either in-house counsel or outside counsel, so that you can have a frank conversation about how your technology works. What I would say is it's always good to understand your own house before going outside of the house, right? So, to the extent you can complete any analyses internally first, that's useful. You want to understand what you're going to be submitting to people outside the house. Under the New York law, there is a requirement that it be an independent audit. And as explained before, the audit, that means that the auditing body cannot have a financial interest in your company. So there is an obligation to go outside of house. I don't know what the intent was behind that change in the regulations, but I think one plausible explanation was a concern, as Airly mentioned, with trying to construe the results in a way that could seem beneficial to the party that's regulated by the law. So this is the back and forth with regulation in the United States, right? There's business imperatives and there's business interests, and those are balanced and sort of channeled by city, state, and federal laws governing that subject matter. So it's a complicated area, and it's made more complicated by the fact, as was mentioned, that it's not just the local New York law. There are federal regulations in this space, state regulations in this space, and other local regulations in this space, which are similar but not overlapping. And for a large enterprise, it's complicated to accomplish all of those goals.
Can I ask you, Ellie, now put yourself on the shoes of a, maybe not of a counsel or employment lawyer, but from a HR manager or one of those IT partners, so they use what would be your take? I mean, compliance is definitely very important. It's like if you don't take it, you cannot use it. But is there any other benefit that you would think would be worth when you're conducting those internal audits?
So we've done adverse impact testing for decades. We have to do it as part of law. But one of the major benefits of doing these New York City bias audit is the transparency requirements. So businesses can say, yes, we're not biased, but there's usually no evidence to support this. They don't make their adverse impact testing public. Whereas with this law, you now have to make the summary of results public. So this can increase trust from candidates. So they can see how someone like them might fare against your assessment. If they had any reservations before, kind of having this pure data and then an explanation of what the data means kind of in lay terms can really just help them to make a decision about whether they do want to interact with this tool or not. So it will help with kind of public image as well as the legal compliance and just kind of make candidates more confident in the use of the tool.
Nice. I'm going to go for a few questions now from the audience, and I'd like to thank everyone for putting so many questions. There is a person called David Mayers, and he has asked multiple questions, I should say. So I'll try to lump them up into a single one. For example, maybe that's something for, it goes into the ADT question, which is, if I use a cognitive ability test as part of an employment decision, would that be in scope? That's one of the questions. But also, he also asked about, for an audit, for example, is it enough to just perform an adverse impact analysis, or there is more that needs to be shown? So maybe Jacob and Ellie, if you could answer both.
Sure. So, there is a universe where a cognitive ability test could theoretically not be within the scope of an AEDT. I could imagine a set of 10 questions where the applicant writes down the answers to the questions, and then you and your fellow sort of cohort of people reviewing the applicants read them and talk about them. In that circumstance, I don't think it would be the cognitive ability test would be an automated employment decision tool. Now, I'm looking at the text of the law. An AEDT means a computational process derived from machine learning, statistical modeling, data analytics, or artificial intelligence, and then that issues a simplified output and other factors. I could also imagine a world where the cognitive ability test is governed by one of these provisions because it is machine learning, statistical modeling, data analytics, or AI tool, right? The fact that it's a cognitive ability test alone is not the question. It's what are the processes that are producing the output, and how is the output being used for purposes of making the ultimate decision?
Yeah, I can imagine if maybe I can say about the multiple ways a cognitive ability test could manifest itself. Can you just say multiple ways? For example, I don't know, I'm thinking games, for example. I mean, if you do a game-based assessment, I can have a cognitive ability test for games, for example, but could be just multiple choice as well. I don't know. Eddie, can you go for it?
Yeah, so if your assessment is, like Adriana said, using elements of game, so if you have sound effects, if you have things moving around on screen, a progress bar, all of these would be elements of gamification. And then if you use some sort of algorithm, machine learning, artificial intelligence, some sort of data analytics to then derive a score from the performance of this assessment, then it's likely that this assessment then would fall within the scope. But as Jacob said, if you are just kind of doing a pen and paper test, it's literally, did you answer this question right, yes or no? And then you're adding up the scores, then it's unlikely that something like that would fall within the scope. So it very much just depends on the format of the assessment, how it's scored, rather than what's actually being measured. So it's not about cognitive ability, it's more about the assessment format and scoring. So yes and no is the answer.
Yeah. What is the, there's a question about liability, which is quite interesting.
Yeah, I can address that. So the law literally has a enforcement provision and a penalties provision. Those provide that the first penalty is $500 and subsequent penalties can go up to $1,500 per violation. Now, each violation, the law expressly says, is each day on which the automated employment decision tool is used in violation of this section. So, it's not insignificant. It can get substantial if for 30 days you are using an AEDT outside of compliance with the law. I'll note one sort of factor about that is that there are some laws in this space where there's a private right of action. A private right of action means that any individual covered by the law can bring a claim in the proper court with jurisdiction to challenge the lack of compliance with the law. New York Law 144 does not have a private right of action. However, in the provision constructing the law, it says that this subchapter, quote, shall not be construed to limit any rights of a candidate under New York's human rights law. And New York's human rights law does have a private right of action. So how we think about enforcement and penalties and liability under the law is very important and not wholly settled yet. Now, no laws are wholly settled yet. That's almost true in every case, but it's uniquely the case with laws that haven't even been passed, and there's a lot of questions about its enforcement.
Yeah, there's a question, I think, targeted to Ellie from Rob McCauley. Sometimes I cannot mention the name of the person that asked the question because it's anonymous, but in this case I can. Ellie, you mentioned some bias mitigation in hiring tools, and I know that you're doing some research around some procedures that could be used. Is it worth mentioning a few techniques and a few things that you have been exploring and things that you've seen has worked or did not work? I think that would be very valuable.
So we can take inspiration from both psychology and computer science here because it is very interdisciplinary. So on kind of the psychology and fairness side, we can make sure that we're using things like a dyslexia-friendly font so that there's increased accessibility. Also use colours that are friendly for colour blindness. Use a job analysis to see whether we actually need to measure these particular constructs. So in the case of cognitive ability, this can lead to bias. So if we don't need to measure cognitive ability, we can leave that out. And that can kind of help to mitigate some bias if we're measuring things like personality instead. And we can also make sure the actual items aren't reliant on some kind of cultural norms, or they're kind of related to an assumption of race, for example. And from the computer science side, we can also kind of directly manipulate the data and the algorithm to make sure that the bias within the model itself is mitigated. So there's kind of three broad approaches to this: pre-processing, training constraints, and then post-processing. So the pre-processing, we can kind of change the data set to remove any correlations between the predictors and protected characteristics. And then so we can examine the baseline model for adverse impact and then have a look at the adverse impact of the mitigated model to see whether it actually worked. With training constraints, we look at the parameters of the model. We can introduce some sort of parameter that kind of reduces or changes the weights of the predictors. And again, we can look at the baseline model and then the mitigated model to see whether the adverse impact is reduced. And then for post-processing, this is slightly less applicable to psychology. It usually involves changing the outputs. So we could change the outputs for a particular group to make the outcomes more balanced. This technically then could be changing outputs based on a protected characteristic. So it is less applicable, but in computer science applications that are kind of less social, this is another strategy we can use. And again, it would be the testing the outputs of the baseline model and then the mitigated outputs to test for adverse impact to see if it has reduced through our mitigations. And we could potentially combine multiple approaches as well. There's been a lot of work in computer science on different approaches that we can use to fulfill different fairness definitions.
No, very good. Very good. There's a question from Kirsty Nolan. Thanks, Kirsty, for the question, which I think it's a tough one, but I'll go for it. Can you list, and that's the easier part, the ethnicity and race categories? I don't think that's too difficult to list. But the difficult one is the question around practicalities of achieving data for all the categories. And if there is any specific or in the law or any other adjacent law or related regulation specify minimum sample sizes, any guidance will be very valuable. Maybe Jacob, you go first.
Yeah. It's a really good question, and it's a tough question. In terms of sort of related laws that you can look at, the EEOC's guidelines, where much of the local law sort of it appears was based off of, and that has been represented was based off of, also reflect rules governing employment and hiring practices. And so those laws have been around for much longer, and interpretations of the EEOC's guidelines on hiring practices are certainly going to be important for the early stage of the New York law, for interpreting it and compliance with it and understanding what you need to do to achieve that. The harder question about practicalities of achieving is it's difficult, right? You know, there are specific rules and there are requirements for compliance. If you're a company that is dealing with a practical challenge of not having a sufficient sample size, the second set of regulations have proposals for what to use in alternative to historical data, and allow for that flexibility in terms of if you don't have the historical data necessary, you can use sample data. But as Airly said, there are provisions regulating how to use sample data in contrast to historical data that you'll want to discuss with sort of thought and care with your internal team, and if necessary with counsel.
Just to build on Jacob's answer, the categories that are specified in the DCWP's example for ethnicity or race are Hispanic or Latino, white, Black or African American, Native Hawaiian or Pacific Islander, Asian, Native American or Alaska Native, and 2 or more races. And it can be difficult to collect sufficient samples, particularly for things like Native Hawaiian or Pacific Islander, for example. So there are, in the example given by the DCWP, these are still included in the impact ratio calculations, but some guidance issued by the EEOC on the uniform guidelines say that these categories should be reported if they represent more than 2% of the workforce. In psychology, there is kind of no hard and fast rule of this percentage will kind of give us an appropriate sample size to make sure that our analysis is meaningful. But generally around 10% or so will give us something that is meaningful. If we don't have sufficient sample sizes, we can still do the adverse impacts analysis on them. We can just kind of have maybe just note that this sample size was small so that the results might be inconclusive. We can potentially use a different category as the denominator in the calculations. There are kind of ways around it, but it is important to include all of the data you have and kind of work with what's available to you.
And if I may just build on that, it's difficult to comply with these laws and the many other sort of United States and other laws regulating sort of consumer-facing products or employment-related products. For that reason, we always recommend that companies think about these from square one as part of the product development process. It's much easier to comply with the laws if the product development process bakes in the requirement to comply with the laws and is considering these requirements as part of the production of a tool that's used for business purposes, as opposed to thinking about it as I've completed my tool and now I have to think about the law on top of it. There was a question here about what's the benefit of these audits on top of just compliance, which I think is a fair question. And the answer is, if you think about it as part of the product development process, it ensures that you're getting correct outcomes, and it ensures you're getting outcomes that are actionable and useful for your business's success.
I totally agree with Jacob at this last point. There are so many questions, and now we're sort of running out of time. And one thing that I don't want to lose out, and I would love to maybe wrap this up, is what's the future looks like. You know, we have the New York City law, which is stirring so much debate. We have GPT-4 now around ChatGPT plus. Apparently, there is just so much events taking place, and we got the UA Act possibly coming this year. New Jersey, California moving in. I don't know. Can you maybe Jacob and Ellie, could you share your thoughts and different things that will happen? Maybe Jacob more on the US and Ellie more on the Europe side.
Yeah, absolutely. The best recommendation I can give to companies right now is that though the laws are varied and complex and different in many ways, so many of the US laws are about transparency and notice to the consumer, or in the employment context, the employee or the person being potentially hired. You know, the regulators are concerned with making sure that when someone is dealing with a product, they know what the product is. There's strong suspicion about products that don't disclose exactly what's going on. And we're seeing more and more of that from regulators across the spectrum in the United States. Even when the technical provisions of the laws are different, uniformly almost, we're seeing notice and transparency as a lodestar for compliance. So in addition to talking to counsel about how to comply effectively, thinking about making notice and transparency essential to your product development process is key.
And just to kind of cover the Europe side, for anyone who hasn't really been following closely, the European Commission has proposed an EU AI Act, which is likely to become the global gold standard for AI regulation. So it doesn't just focus on recruitment, but it does take a risk-based approach. Those at the lower level have either no obligations or just transparency obligations, whereas those at a high risk, including those that are used in recruitment, they have more stringent obligations. So for example, adopting a risk management framework, making sure the data is of good quality, and again, transparency requirements. So it's likely that laws like this are likely to snowball. So in the US, the New York City one has kind of already influenced other jurisdictions. So New Jersey has introduced a bias audit law. It's focused more on the sale of the tool rather than on the applicant side, but it is the first version of the text. It could evolve and become more similar to New York City. And the EU AI Act is probably likely to influence regulations around the world. So we could see similar provisions being introduced here in the UK, or they might kind of adopt some of the contributions of the EU AI Act here. So this New York City law is just kind of the start, and we're likely to see many more laws across the world kind of coming into effect and being proposed within the next few years.
Nice, yeah. It feels like the bigger play we're discussing here is transparency. And the New York City law, even though we focus so much on bias, it feels way more like a transparency form of legislation than anything related to bias in many ways. I know that we are approaching, there has been a deluge of questions. That's the only thing I can say. We will have more policy hours, probably also around this topic. I presume this is not the end. This is just the start of a conversation. What we will do is we will collect these questions and probably come up with a FAQ sort of, and then we will probably publish a blog or something. So please keep tuned, and we will hopefully address many of the questions here. Questions around the auditor quality, questions around the data supply being skewed, many questions that had to do with the practicalities, and I definitely appreciate the complicated ways and the maze that feels like navigating this and any future legislation in this space. But in any case, I just want to thank Jacob and Ellie for taking part in this edition of the Policy Hour. Look forward to having more, Jacob, as well as you, Ellie. For all I just want to say thank you very much for attending. We will definitely be in touch, sharing more information and future events. But for now, thank you and have a good day.